Parkinson.
Yeah, exactly.
I have no objection to that, Your Honor.
All right, so I'll go ahead.
That was a mistake. The clerk and me, when we were filing the subpoena, that was not to go to Olivia Parkinson, file a dismissal for the BPO. She did not do so. She did not file for an enforcement motion either that I requested her to do before Christmas. She told me that she had a rape case that she had to attend to that was more prior and important at that time. And we did not meet, so we did have a lack of communication. I feel as though she put more of her effort into the rape case and not mine. And so there was a breakdown in communication, and we're here today without any sort of, communication at all. So I agree with her motion to withdraw.
All right. Ms. Yeager.
Judge calmly shuts the door on another delay, granting withdrawal while exposing a pattern. Multiple lawyers, repeated breakdowns, and a defendant steadily burning through representation without resolution.
Okay, so a couple of matters that we need to address. Number one, the defendant, pro se, prior to the withdrawal of Ms. Ilola's counsel, filed a motion to enforce. That was filed on the 16th of January. In essence, the defendant is asking this court to order a different court to take legal action. This court has absolutely no authority to do that. Certainly the defendant could seek a writ of mandamus from the Ohio Supreme Court, asking it to order the Domestic Relations Court to proceed. But
repeat this, that? I barely can hear you. I'm sorry.
Well, here's the thing. This court does not have any authority to tell another court what to do, all right? So I'm going to deny your motion to enforce. Now, there are certain other steps that you can take to try to get the relief that you sought from this court, but obviously that's something that you would have to do at this point on your own. Now, the other thing that was pending, and has been pending for a while, is the defendant's motion in limine regarding the use of a recording which purports to capture a conversation between the defendant and at least one, if not several, individuals at the Domestic Relations Court. The allegation being that the recording itself was made not by Mr. Bishop or the individual that he was speaking with, and in fact the state seems to concede that fact in its memorandum contra the motion to in limine. And the court did considerable amounts of research yesterday afternoon, and here is basically what I found. Normally, a statutory violation is not remedied by exclusion. For instance, if an officer stops an individual for operating a vehicle while impaired outside of their territorial jurisdiction, that's actually a violation of law. But because it's not a constitutional violation, a defendant would have absolutely no relief or recourse to seek any type of exclusion. Here, however, there are specific statutes, I should say, that...
This is the hard stop moment. The judge makes it clear one court cannot command another, cutting through confusion and firmly denying the motion with no wiggle room left.
Number one, prohibit and outlaw the interception of oral communications, and there are specifically statutes that indicate, and I will quote, no part of the contents of any intercepted oral communication shall be received in evidence in any trial if the disclosure of that information is in violation of sections 2933.51 to 2933.66 of the Ohio Revised Code. That's 2933.62A. 2933.52A1 prohibits the interception of an oral communication, and the subsection A3 of the same statute prohibits the use of the contents of the intercepted oral communications. So it would appear that the defendant's motion in limine is well taken, and I will preliminarily grant that in order that the defendant, or that the state, not use the recording itself in its presentation of evidence in its case in chief. That does not preclude the state from introducing evidence from individuals who were either part of the conversation or individuals who overheard the conversation as it occurred and who have a source of knowledge of the contents of the communication, not from the recording, but rather from their own auditory senses. So the court will be putting on that entry. Now we need to address the issue of counsel, or maybe we probably should have done that first. It doesn't really matter because the last time we were here, when Mr. Iteum withdrew his counsel, the court did indicate and explain to Mr. Bishop that I would be reaching out to the Ohio Public Defender's Office to see if they would be willing to represent him. Thankfully, they were, and I explained to him that if they weren't, or if that didn't work out, that the court would very likely declare what's called a constructive waiver of counsel. So I've done a little research in that regard as well. There's a case out of the 5th District, actually, from April of last year. It's in re adoption of AMV.
Here, the courtroom flips. After detailed legal reasoning, the judge rules the recording unusable, stripping the prosecution of key evidence and reminding everyone that procedure still matters.
His right to court-appointed counsel, but that if 2 were enough in that particular case, I think 5 is more than enough in this one. So the court is going to declare a constructive waiver of the right to court-appointed counsel, and I will explain to you, Mr. Bishop, that you have 2 options. Number 1, you can hire your own attorney using your own funds. Number 2, you can represent yourself. Do you understand that those are the 2 options you have?
Yes, Your Honor. May I have a chance to speak now?
As soon as I'm finished.
Yes, Your Honor.
I need to advise you of the perils of self-representation. I want to confirm with you that you did not go to law school, nor do you hold a law degree, correct?
Correct.
You've never been admitted to the bar of any state to practice law, correct?
Correct.
Well, here's the thing. If you elect to represent yourself in these cases, you will be held to the same standard as somebody who has been to law school, who has passed the bar, and who has the experience of practicing in the courts of Ohio. The court would not be permitted to advise you on how to proceed. You could very well miss certain opportunities to improve your circumstances or plead your case. And that would be a risk that you would be taking by the fact of refusing to accept the assistance of court-appointed counsel.
Objection to that motion right there, Your Honor. I didn't refuse counsel. They've refused me. I would like that worded correctly. Sorry.
Well, Mr. Bishop, here's the thing.
They have all told me.
Here's the thing, Mr. Bishop.
Yeah.
Them not telling you what you want to hear is not the same as being ineffective, okay?
That
You may disagree with what they have to tell you, but they know more about the law than you do. I'm fairly confident in stating that.
That wasn't the case, Your Honor. I was being forced to take a plea deal when I wanted to come to trial. That is illegal. That is against my judicial standards of right. Every single attorney you have given me so far has told me to take the disorderly conduct on this telephone harassment, and they'll dismiss the VPO. And every single one of them has told me this plea deal that they are going to come to the prosecutor with, and that they want me to take that. And I have said, no, don't you dare go to the prosecutor.
Tension peaks as the judge declares a constructive waiver of counsel, a warning of real consequences while rejecting conspiracy claims and making it clear self-representation is a risky final choice.
What was it you wanted to say?
Thank you, Your Honor. I'm sorry. If I don't speak, I lose it. So I'm not my father, so I'm not a professional, as you said. So I'd like to just make a motion right now. I was under the impression we were going to trial today, and that is what I came here prepared 100% for a trial today for the VPO. I am going to ask for a continuance and ask that we push the telecom harassment out for a few months, because I do want to retain counsel. I'm going to sell my father's Mustang and retain counsel. So it's going to take me at least a little while, and I'm in school right now at C-Tech for 5G broadband. So and it's already paid for. I've already put $2,200. This case is over a year. My life doesn't stop. I've got kids. I got child support. I have to work, and I got to go to school. So I'm asking that. My graduation is after March 20th. We've pushed this out this long. I ask that if we do the telephone harassment, that we do that one past March 21st so I can graduate. As for the VPO, I would like to make an oral motion right now and agree to your waiver to counsel for myself, and I don't need appointed counsel. I will represent myself on a separate matter of the VPO, and let me get the case number for you, Your Honor, for the record. Do you want me to stand on this, Your Honor?
You don't need to stand when you address the court. That's all right.
I would like the case number 23 CRB 1774A to note that I will represent myself on the VPO.
Okay.
And that I am going to request today as well an oral motion of dismissal, because I was under the impression of a trial today. I am prepared for trial. If state is not prepared for trial today, I ask that they withdraw and dismiss.
All right. Ms. Yeager?
Your Honor, Mr. Bishop speaks prematurely about our preparedness. However, in speaking with court staff yesterday, we were instructed to call off our witnesses for the VPO case. So we would be unable to proceed, but we did that based on the impression that this matter would not be going forward today. Regarding...
Objection.
You have to let her talk, Mr. Bishop.
Regarding the pushing the telecommunications harassment case to after March, we would object to that. These cases are from 2023. This has already gone on long enough. The defendant has a right to a fair trial, but the victims also have a right to a speedy trial as well. So we would object to just pushing that just so that he can graduate and sell his father's Mustang. Those are things that he should have already been prepared for. And since he did mention a disorderly conduct, we did want to just clarify for everyone, the state's offer has never been for a disorderly conduct. The state's offer has always been plead to the telecommunications harassment, and we would dismiss the protection order violation case. That's still what our offer is. However, if we do go to trial, we will be prepared to go to trial on both. Thank you.
Your Honor, that didn't address my motion to dismiss.
And we are not dismissing.
Well, I was going to say, she doesn't really have to address it if she doesn't want to, but... Okay, as far as your indication, Mr. Bishop, that you wish to waive your right...
The defendant pleads for time, school, kids, money, only for the prosecutor to push back hard. Speedy trial rights collide with personal hardship in a decisive courtroom clash.